Chapter 6, Part 8, Video 8. We left off talking about the intentional torts against property. Now we're going to talk about unintentional torts. Unintentional torts are probably the most common type of tort upon which people bring lawsuits. Generally things like automobile accidents, slip and fall situations, those kinds of things. So an unintentional tort is a wrongful act that the tortfeasor committed without knowing its wrongfulness or without intending to commit the act. Negligence is the type of unintentional tort. Negligence is a failure to live up to a required duty that one person has to the world or to another person to exercise reasonable care under the circumstances. There is no intent requirement, only the creation of a risk of harm and the consequences that that risk can result in for the plaintiff. However, that risk has to be foreseeable. We'll talk about that later. So the key thing to know is that for any negligence case, there are 4 elements. Some say 5, but we'll keep it at 4. Okay, the first is duty. The defendant owed a duty to the plaintiff. So if the defendant runs a stop sign and runs into the plaintiff's car who is going on the road and had the right of way, then the defendant breached their duty. The duty having been created by the law that says that you have to stop at a stop sign and you have to give way to the other car. Okay, so the breach of the duty there was running through the stop sign. Causation has 2 elements to it. That's why I said some people say 4, some people say 5 elements. So the 2 elements to causation are what we call cause in fact and proximate cause. Okay, cause in fact is easy. Cause in fact, the law has established really 2 principles, but one is the one that occurs in most situations. And that is the but-for test. And so we simply say, but for the defendant's actions, would the plaintiff have been injured? And if the answer is no, then there's no negligence. If the answer is yes, then we know that the person would have been was injured because of the negligence of the defendant. Okay? Proximate cause is much more difficult. Proximate cause didn't come about originally, but was developed in the early 1900s and came about as a result of the famous Palsgraf case. I don't have time on a video to get too much into the Palsgraf case, but basically another way of looking at proximate cause is it's a legal limitation to causation. So even though you pass the but-for test, there is a limitation to liability based upon whether or not the negligent act could foreseeably have caused the injury to the plaintiff. So in the Palsgraf case, Mrs. Palsgraf was sitting on a bench next to one of these large scales that they used to have in the beginning of the 20th century. And there was the Long Island Railroad, and a man was trying to get on the train. The man had his arm like this, and inside his arm he had a newspaper wrapping something inside. The train started moving, and the man was trying to get on, and a couple of porters pushed him up to help him into the train. Unbeknownst to them, he was actually carrying fireworks in that newspaper. They were dislodged, they landed on the floor, they exploded. They shook the ground, which caused the scale to fall over and hit Mrs. Palsgraf. So in the Palsgraf case, the court adopted this concept of proximate cause and said simply that was not foreseeable from what the defendants, the porters did, that would have that effect. There's a lot more to it. There's also a dissenting view on that. I'm not going to get into it in this slide. It's way beyond the scope of necessity in a business law course. But proximate cause is an element of the tort of negligence, and it is a foreseeability issue. The plaintiff has to have suffered some damage, some legal injury. Okay. Now the duty, where does the duty come from? The duty can come from a statute, from common law, or from the standard that we apply to how a reasonable person should act in a given situation. So the courts will look at the nature of the act, the manner in which it was performed, and the nature of the injury. Negligence per se is where there is an actual statute that establishes the duty, such as a stop sign, and you run through it. In that situation, you don't have to prove that running through a stop sign is negligent. It's negligent per se, meaning it's automatically negligent. Okay. Res ipsa loquitur is a doctrine that is used sparingly in the law, but the Latin phrase means the thing or matter speaks for itself. It's a situation where the outcome would not have happened absent some negligence. So for example, if you're walking by a warehouse and a barrel falls on your head from up above, that's something that would not have happened absent some negligence. Somebody was negligent either in pushing the barrel over, in storing the barrel, or something to that extent. So it creates a presumption that the tortfeasor was negligent by pointing to certain facts that infer negligent conduct without exactly showing how the tortfeasor behaved. Oftentimes this is a doctrine that's used in airplane crashes, because airplane crashes do not occur absent some type of negligence or intentional tort activity. Again, we use the reasonable standard criteria for determining duty, and that is how a reasonable person would have acted under the circumstances. This is an objective standard, a hypothetical reasonable person. We don't look at the particular person. So if a particular person has some limitations, perhaps mentally or physically, we don't look at that. We look at a hypothetical reasonable person, an objective standard. Okay. Landowners have certain duties to people who come on their land, which we talked about before. They're expected to exercise reasonable care to individuals coming onto their property. Historically, the law drew distinctions between licensees and invitees. More states today are doing away with that and applying one simple standard like you have here. One of the growing areas of law, which falls generally into the area of negligence, is the area of my brain's got a clog in it here. Oh boy. It has to do with property and accidents that occur on property that are aimed at the landowner. So for example, common things today are apartment complexes where somebody breaks into somebody's first floor apartment through a window and is injured, okay, by an attack by that invader. Okay, the law has developed that the property owner, if they were aware of similar situations, like say 2 weeks before somebody else's apartment was broken into, then they may be liable because of an increased duty, duty of the property owner. Thought of the word. It's called premises liability. Okay, so there's premises liability when a property owner is on notice that they may have a higher duty than normal. So this occurs in a lot of apartment complexes today and rental property with situations like I just described. Also situations where people have been robbed or molested walking through common areas that were not well lit, and the apartment owner knew of this and didn't increase the lighting. So again, we apply a reasonable person standard, and that is, would a reasonable person who had known about these prior incidents have taken steps to prevent such things from happening. So this is in addition to your ordinary duty of care to people who come on your property. These extra duty, so to speak, comes about as a result of knowledge of a particular possibility or threat. Very common today, particularly in large cities where we have lots of crime and lots of apartments and areas that may be dangerous. Hotels also have similar issues. Okay, so here is the traditional difference between a licensee and an invitee and the duties owed. And as I said, we've done away with some, in most states, with the distinctions, but nevertheless, this gives you a good chart so you'll know if you're in a state that still makes the distinction between an invitee and a licensee. Okay, so we're going to stop there and we'll pick up with, I believe we're up to video 9 maybe, or is it 8? Well, at any rate, I'm going to go back to here and we'll show you this in the next one so you'll know it's the following video.